Good evening, everyone. My name is Kathy, and I would like to welcome you all to the Harris Law Firm's webinar series, Wiser Together. Today's webinar, we will be discussing what does no-fault divorce really mean? How does adultery and addiction affect divorce? And we are grateful you were all able to attend. As a member of a Colorado community for over 30 years, the Harris Law Firm has always tried to give back. This and future webinars are a free service we provide to that community. Now, I would like to introduce our presenter today, Jenny Ray. Attorney Jenny Ray, one of the Harris Law Firm's most accomplished attorneys and a partner at the Harris Law Firm, is a passionate advocate who has dedicated her professional career to making the law clear and accessible to those who need it most. She has helped numerous individuals and families protect their rights in high-stakes family law cases. And now I'll turn it over to you, Jenny.
Thank you so much, Kathy, and welcome everyone. Thank you so much for being here today. I really appreciate you taking the time out of your busy schedule to meet with us. And certainly wanted to address this very important topic. But before we jump into that, I wanted to also kind of just speak about a few housekeeping items, if you don't mind. Number one, I just want to make sure that it's clear that this webinar does not create an attorney-client relationship between you and the Harris Law Firm. Simply put, we just want to make sure that we are providing this as general information to the community, just as Kathy mentioned. We like to try to have, kind of informative sessions that, are on current topics that, we face quite often. And so, like I said, again, we very much appreciate you taking the time to meet with us. And should you wish to further any attorney-client relationship, then we certainly, as mentioned, reach out to Kathy and she can certainly schedule you an appointment with us to have those further conversations. Secondly, as you can see that we are working via Zoom today. We're still kind of working in this working remotely environment. And just so you know, just as Kathy mentioned, if your internet connection happens to go, if my internet connection happens to go, I will tell you that if mine happens to go, I will be on very quickly back on. So just please just give me a few moments and I hope to be back on. But also, as mentioned, like I said, we're working from home today and, you may hear a dog barking, but hopefully that shouldn't disrupt anyone. So without further ado, let's jump into it. So certainly, as I mentioned just a moment ago, I think it's important for us to discuss this very important topic of adultery and addiction and how to navigate, how those two kind of issues and other issues as well, kind of how are they relevant in a state where it's a no-fault divorce state? So just kind of wanting to kind of move right ahead here. Let's see, please bear with me. I'm not the greatest at PowerPoint, so my apologies. So I wanted to kind of just make sure that we're talking about a bit of an overview of what we'll address today. So, certainly I will be discussing what a no-fault divorce is, certainly context, in its applicability here in the state of Colorado and other states as well, and kind of a history of the same. The exceptions, certainly, well, where might this information be relevant and, where is fault allowed, kind of distinguishing between the two, if that makes sense. Again, also then kind of diving deeper into it. Okay, well, how about in these very specific kind of circumstances in this no-fault divorce state? How are these kind of specific issues kind of applicable? And then we'll have a cute question and answer period. All right. So kind of jumping into it, the definition. So a no-fault divorce. Well, what the heck does that mean? So a no-fault divorce state means basically where a petitioner seeks a divorce and they not need proof a fault-based grounds or wrongdoing to end a marriage. So meaning that you don't have to wait for something to happen in order to get a divorce. Certainly there has to be a factual finding, and I will kind of describe that here in a moment, but there's no need for kind of specific kind of instances to be present of wrongdoing to be present for a person to seek to end their marriage. Put another way, you don't need to sue a person, your spouse. We hear here in Colorado, like personal injury lawsuits, where they're seeking for damages or something of the sort. And that's not necessary here in the state of Colorado. What you're seeking from the state of Colorado is basically asking for the court to dissolve your marriage. You're not suing the other person. You're just asking for the court for a legal document, a legal finding that your marriage is no longer intact, that the court has dissolved your marriage. And frankly, some folks say, well, what if my spouse disagrees with the divorce? What if they don't wish to move forward? That doesn't matter here in the state of Colorado. A divorce can be granted upon the request of either spouse. So a bit of the rationale. So one might ask, well, why do we have no fault states, right? Simply put, what the idea is that sometimes folks, basically just their marriages end, the relationship has changed. There's really no sometimes in certain circumstances, there's no wrongdoing on a person's behalf. Sometimes just the relationship ends. And so, certainly, as I mentioned here, the social acceptance, that sometimes really like marriages just end, the relationship has shifted. We no longer want to be in a marriage. Another kind of idea behind the idea of the principle of no fault divorces is to make it more efficient in court. As you can imagine, the attempting to prove that someone is at fault or not at fault, it can cost a significant amount of money and pain and suffering of having to go through that litigation. And so this simply is, the idea being is like, well, let's make it more efficient for couples to attempt to receive a dissolution of marriage. It's a simply put as, you're trying to not have to as discussed here below in the next kind of bullet point is you're not airing out your dirty laundry, so to speak, right? So it's also an attempt of trying to allow for folks privacy when they are going through this divorce. Now, sometimes there's reason to bring out certain factual circumstances, as the title of this webinar kind of indicates. But the attempt behind kind of no fault in that principle is to, okay, let's kind of try to maintain some sort of privacy for these folks. And as I mentioned here below, proving that fault increases litigation, certainly hurt feelings, costs, etc. And lastly, I have here, it discourages forum shopping and promotes uniform application. And what I mean by forum shopping is that some folks, as you can imagine, because we're all human beings, right? So you may go before a judge in one particular circumstance and arguing fault, and they may not agree that you've proved enough to prove fault, but the judge right down the hallway may believe that you have. And so the idea being is that, okay, let's just remove that kind of piece altogether and simply have it as no fault kind of designation. Are there disadvantages to this kind of philosophy? Certainly some folks may say yes. And you may have a feeling of, certainly of possible disadvantage, meaning, just something to kind of be aware of when you're walking through a divorce process of that, some folks may not feel as though they've had their kind of day in court to describe these things. Well, my spouse has committed adultery on me and I found all of this, all of these facts and all of this evidence. What am I supposed to do with it? And that's, again, as I mentioned, we can certainly discuss further in this webinar, but I sometimes you don't get to talk about it, right? And as it, depending on the facts of the matter, you might not get to kind of get those feelings resolved and have that sense of closure with that, because the court may not find it relevant, depending upon the facts. One person may say, well, it's my spouse's fault that, this marriage is ending. They did this, that, or the other. And certainly, as I mentioned in that first bullet point, it removes accountability for the breakdown of the marriage. It's not necessary, the court may not find that it's necessary to assert that accountability to one person or that responsibility to a person. So just kind of remembering those things. And also with at-fault divorces, because the court can find fault, it's this person's fault that there's this divorce, etc., and they can apply and kind of their financial kind of circumstances. Well, okay, well, because you've done this, then you'll be responsible for this debt, or what have you. So if that makes sense. So no fault states it can remove some of these pieces. Just a little bit of background, history in the United States of a no-fault divorce. The first state was California in 1969 by then Governor Ronald Reagan, and he actually was divorced, and he became the first president that was divorced. And there's only been two. New York was the last state to adopt kind of this no-fault kind of principle in 2010. So it's ironic that it's been this kind of span of time. But now every U.S. state plus Washington, D.C. now has some version of no fault. And as mentioned, you no longer must prove grounds for wanting a divorce or fault of one party, such as adultery, abandonment, insanity, etc. Sometimes, this similar kind of feeling and sentiment is heard through irreconcilable differences in some states like California. And also it's kind of taken this kind of newer kind of principle of this consciously uncoupling kind of phrasing. Around the world, England and Wales adopted it in 2012, Australia 1975. I'm sorry, not 2012, 2022. I'm so sorry. Russia in 1917. And it's allowed in some countries, but only after lengthy separation. So as you can imagine, it's applied kind of not so uniformly across the globe. Certain countries have different requirements, as mentioned here, like a lengthy separation, or in the next bullet point, but only upon the request of the man. True no fault is not universal. So Colorado is only one of 18 states where only no fault divorce exists. In the remainder, there can be kind of this fault application. So I know that there's many states that have kind of this kind of dual application, that you can either choose to go with the no fault or you can choose to go with fault. But as you can imagine, the waiting periods, the grounds allowable for that fault all differ. And the ground, certainly looking at different states, the application for filing for divorce and what one can seek with regard to the divorce and the time periods, as I mentioned below or there, they vary from state to state. However, with regard to Colorado, which is probably why you're watching this webinar today, you have to prove domicile. So what does domicile mean? It's basically meaning that you intend to reside in the state of Colorado. You intend to call Colorado your home. And some folks, they may be, serving overseas with the military, or you might be living abroad for a period of time, going to school, or for some other reason, but you consider Colorado your home. You hold a Colorado driver's license. You hold a Colorado voter registration card. You hold you do your taxes here in the state of Colorado. As far as which state you file your taxes, you file your Colorado state taxes. Those are all things that can prove your domicile here in the state of Colorado. And with that, you assert I am a resident of the state of Colorado. You also have to prove once you filed your petition for dissolution of marriage and the accompanying summons for dissolution of marriage, you have to either prove that you have personally served your spouse or that your spouse has signed a waiver of service. Now, can I simply go to my spouse and hand him documentation that I wish to file for divorce? No, that does not qualify as personal service. What that does is basically, in order to completely comply with the rule of service of process, you have to have a person that's over the age of 18 that knows the rules of service and that they are not involved in the case whatsoever. And so you can't have your kiddo do it, or so just kind of keeping those things in mind. That's why many folks will oftentimes hire a sheriff's officer to serve documents, or hire a private process server to serve a person with documentation. And a waiver of service is basically just a document, and those can all be found online. A waiver of service basically says, the person, my spouse, could sign the document saying, look, you don't have to personally serve me. I know of this action. I've received the documentation. No need to personally serve me. So if you have that document signed, then that can also constitute that service is proper. The court also has to have jurisdiction over any children as well, in order to make orders regarding the kiddos in a divorce. And so in order to have jurisdiction over the children, the kiddos have to be here for 182 days prior to filing, unless there's an exception that exists. Also, with regard to the domicile requirement, you have to be a domicile of Colorado for at least 91 days before filing. So, and then there's an additional requirement of the 91 days after filing before the court can issue any permanent order and decree of dissolution of marriage. So basically, the court has to wait that cooling off period, if you will, from the point of filing and serving your spouse until they can enter those final decree of dissolution of marriage. But last but not least, the court also, which is basically like why we're here today, finding that the marriage is irretrievably broken. And as mentioned, this is the sole basis for divorce in the state of Colorado. As required by statute, the judge must make a specific finding that the marriage is irretrievably broken, and that can be found at Colorado Revised Statute 1410-110. And the purpose is, as mentioned here, to make the law of legal dissolution of marriage more effective for dealing with the realities of matrimonial experience by making an irretrievably breakdown of the marriage relationship the sole basis for its dissolution. So again, this is asserting the no fault kind of principle to our dissolution of marriage laws here. Well, what the heck does irretrievable breakdown mean? So again, we kind of do this in layers, right? And again, I'm from Tennessee originally, so my apologies if if I'm saying weird phrases or what have you. So but so yes, what does irretrievable breakdown mean? So it's basically asserting to the court that you find that there is no possibility of reconciliation. And as mentioned here and before, it can be proven upon assertion by either party if no objection. If one party objects, the court can order counseling for 35 to 63 days, essentially meaning that if one person were to file and the other person says, well, I don't know if I believe that the marriage is irretrievably broken, the court can literally place your matter in what's called an abeyance, and basically place your matter kind of on the back burner of the court's docket and say, you know what, you all can attempt reconciliation. You all can go explore the ideas of counseling in this reconciliation. And to determine whether or not you find that your marriage is irretrievably broken. And now you would have to follow any court orders or anything of the sort that's required with regard that's currently in place with your matter. So it's not like the court would dismiss your case outright. those orders are still in place. However, they're, like I said, they're just kind of placing you on the back burner for now, letting you kind of explore those ideas. Also, I've seen the court, if there's an objection by one party, the court may hold a hearing to determine if the marriage is irretrievably broken. And I've seen it a couple of different ways. I've seen the court literally say, we will be setting this matter for a hearing. And that's to discuss kind of the factual nature. Well, here's the reasons why it's irretrievably broken. This frustrates me. We argue about finances, and, they had an affair, and et cetera. And so having those that is certainly an area where, certain things, addiction problems, et cetera, would most definitely be applicable. And so, but I've also heard the court simply ask, instead of holding a hearing on those topics, simply ask a series of questions as to why they believe that the marriage is irretrievably broken after they've heard the objection from the other party. So basically asking the person saying it's broken, well, why do you believe so? Okay. But also, I always want to make sure that folks know here too that, but if one party wishes to have the divorce occur, that person has the right to get out of the marriage. And so I have never seen the court basically hold a person married to the other person if they find that the marriage is irretrievably broken. 2 points for discussion. So, again, the title of this webinar is like, well, addiction issues, adultery, how can these things, how can I discuss these issues before the court? Because I find them important, and they're the basis of why I wish to get a divorce from this person. Like, how can this information be brought before the court? The court will say, now I'll kind of back you up a step and kind of give you a little bit of a, kind of a personal experience in having discussions with my folks. And, I'll have situations where, the person has felt like this information is so very important, because it is. It absolutely is. And folks should not forget that. I talk about the relevance here, but those are very important issues, and you are valid in your feelings of how important they are. It's just, I have to ask kind of further kind of follow-up questions when I'm discussing those issues. So say if my client comes to me and says, my husband or my wife has had an affair, and I want to make sure that the court knows about it. And I say, well, we have to dive a little bit deeper on that. So tell me, not to make this even more painful, but let's discuss, kind of, can you tell me if this affair has resulted in any marital waste, or are the children being impacted by this affair? And so that's why I have these 2 bullet points of this marital waste, in marking the difference between marital fault versus economic fault, and that it can potentially be relevant to the best interest of the child. So I'll kind of take those 2 pieces in turn. Let's take with regard to the children's pieces, because always, always, always the court's going to find that the children are the most important kind of topic for discussion. So here in Colorado, a bit of background. The basis for all custody determinations in Colorado is the application of the best interest standard. Now, I kind of use that child custody kind of determination a bit loosely, just so you know, like, you won't hear a judge use those terms. Child custody, we call it here in the state of Colorado the allocation of parental responsibilities. And I use child custody just because oftentimes it's, folks across the nation are familiar with this term, right? Different states call it different things, like physical or legal custody. But here in Colorado, we call it allocation of parental responsibilities, because we're basically saying that, instead of like this possessive nature over a child, custody, if you will, we like to basically say, well, who's responsible for these kiddos and how are those things allocated? But that best interest of the court standard is found there at that statute, Colorado Revised Statute 1410-124. And if you do a quick Google search, you'll be able to see those enumerated factors. There's many. And there's also a catch-all of just saying, and anything else if I find it important. Which is a nice kind of catch-all, if you will. But just to know that that's the standard that the court has to apply. I also thought that this was an important kind of um, almost designation and declaration. The court shall determine the allocation of parental responsibilities, including parenting time and decision-making responsibilities, in accordance with the best interests of the child, giving paramount consideration to the child's safety and the mental, physical, and emotional conditions and needs of the child. So again, that can be found at Colorado Revised Statutes 1410-124. And basically meaning how would the addiction problems, the affair, the adultery, how does that impact the child's safety and the physical, mental, and emotional conditions and needs of the child? And that's kind of the tie-in, if that makes sense. So I will tell you, just from my experience, just even the language and letter of the law is a very subjective kind of application. As you can imagine, one person, again, may have a very different kind of perception than the person right down the hallway. So as I mentioned down below, it's a very broad definition. Judges have tremendous discretion. So if you have questions about that standard, you're more than welcome to contact us. Here, I kind of wanted to kind of pull that in. Well, certainly, as we kind of all, logically can think about, are that addiction problems can absolutely impact the mental health of the children. Certainly addiction problems, those can have huge impact on parenting time, decision making, etc. As you can imagine, well, some folks may say, well, look, drinking alcohol is a legal activity in the state of Colorado. How can the court enter orders that limit that person from consuming alcohol? Well, the state of Colorado is charged with making sure that minor children are safe. And with that, they can certainly enter orders if they find that, it's necessary for, say, like someone, with kind of an addiction problem. We need to have certain parameters in place. Now, again, I mean, I will tell you what I have told many folks, well, I have seen situations where they come in and say, well, my spouse has an addiction problem. They do not need contact with the children, and they don't need any, responsibilities over the children. And I will tell you that I have seen, as mentioned, courts kind of attempt to maintain that relationship if it's, again, kind of back to this provision right here, giving paramount consideration to the child's safety and the physical, mental, and emotional conditions of the needs of the child. If they find that that's appropriate, meaning that if we put certain safeguards to combat and handle and deal with the addiction problems, then I have seen the courts continue to encourage that parent to be involved. Certainly, well, what about the adultery piece? Is that relevant to the best interests of the children? Well, it can be. Certainly I have seen, circumstances where the court has, where a person has introduced a new significant other to the children too fast, too soon, and making them call them mother or father. I will tell you, in the state of Colorado, taking away that parent's title and saying, oh, well, this is your new father or this is your new mother, can have significant and not forgiving application to you. I've always suggested to folks, if there is a new person involved, and even if it's a step parent, have a different name, not call them mom or dad, or um, have a new name. Don't use those titles that are previously applied to your parents, the parents of that action, if that makes sense. But as mentioned here, like I said, exposure to the intimacy with new significant other. I've seen situations where that can very much have a huge impact on the child. And so the court will certainly care and will want to know those facts. And so that's again where, even though Colorado is a no fault state, those types of facts would be applicable in this circumstance. Again, down below, I say anything that arguably impacts the emotional or physical health or development of the child. Taking it to the marital waste kind of conversation and discussion. So, that's kind of, we're going to kind of talk about, the financial pieces, kind of shifting away from the kiddos pieces and shifting to kind of the financial pieces. So in the state of Colorado, in order to get divorced, the court will most likely divide marital property, and the standard for that is equitably. Now, as you can imagine, that term equitable means can have also very subjective kind of impact and interpretation. And so is that necessarily equal? I have many folks that ask that question. Well, it's 50-50, right? I've seen cases where the court's not dividing things 50-50. I've seen 60-40 splits. I've seen 70-30 splits. It just completely depends upon the nature of the circumstances and the facts of the case. So this might be where the addiction kind of concerns and the money spent for that, and adultery kind of pieces kind of also come into play. So what is marital waste? It's simply intentional or reckless misuse of marital funds for purposes that do not benefit the family or the marital estate. And it's basically dissipating your marital estate, meaning that your marital estate is at this level, at this amount, all said and done, but you're dropping that amount by doing certain things, albeit spending it on drugs or alcohol, spending those funds on a potential new significant other, etc. So the court can absolutely take those things into consideration in that application. As I mentioned below, can apply both to actions prior to the filing of the divorce as well as during the pendency of the divorce. So, what I like to make sure that folks know is that before and during a divorce proceeding, you're basically under a microscope. And your actions, certainly folks can track kind of spending habits, etc. Through and acquire the information to research all of that through a dependency of a divorce action. And so I also mentioned here, if it's the latter, it may also be considered the violation of the automatic temporary injunction, which is located on the face of the summons for dissolution of marriage action that's filed with the court. Now, that automatic injunction, there's, usually 3 or 4 prongs dependent upon whether or not you have children. Number one, the first prong is that you cannot encumber, transfer, liquidate any marital property beyond the necessities of life or in the usual course of business without the consent of the other person. The second provision is that you cannot disturb the peace of the other person of the action. Number 3, you cannot remove any children from the state of Colorado without the consent of the other person or further order of the court. And number 4, you cannot cancel, terminate, or allow to lapse any insurance coverage. That can be life insurance, that can be medical insurance, that can be renter's insurance, homeowner's insurance. You cannot allow those things to cancel or terminate or allow to lapse. And simply put, that's like your first order that's entered by the court that you must follow. And that is what I say down below. If you are spending and committing marital waste, then it could be considered a violation of that automatic injunction. And that goes into place once the matter is filed and the other person is served or has signed that waiver of service. Examples of marital waste. Certainly, as I mentioned, spending on extramarital affairs, right? Um, Now, one question, spending on addictions, gambling, drugs, pornography, etc., selling or squandering of marital property for less than the fair market value. So I'll kind of take the first kind of bullet point here, spending on extramarital affairs. I've seen folks, pay for gifts, pay for going out to dinner, and dates with, in their affair. That's arguably considered marital waste because you're reducing what is intact for this marriage, this marital estate, and the person committing that extramarital affair and spending that money on trips, extravagant trips, etc., and reducing that could be considered as marital waste. As mentioned, again, the spending on the addictions and drugs, pornography, etc., that can also, you are taking your marital estate and reducing it, and that is not in the necessities of life or the usual course of business. And again, I always like to make sure to kind of discuss this kind of last piece too. I've seen situations where the court has, or where a person says, well, I'd sold that, four-wheeler to my buddy, and that was only worth $50. And the court's like, well, I'm looking right here, and it actually is worth a significant amount more. And so that can absolutely be considered marital waste. Complications, as I mentioned, well, how do I track that? How do I know that this occurred? How can I prove that before the court? That is oftentimes one of the biggest problems. How do you discover that waste has occurred? If I see, certain charges at a grocery store or department store where, like the Walmart or Target or something of the sort, where, usual charges kind of occur as, kind of, they seem kind of like in general very similar to one another. You can see that the person kind of does all of their shopping for the week on a Sunday or something of the sort. But then, if you see something kind of outlandish, like, well, there was a $500 charge at the Target, but that seems kind of out of our norm. Folks will sometimes utilize gift cards to be able to kind of then go on different dates or anything in those kind of affairs. So those are the types of things that, you really want to make sure that you're trying to watch and observe. Ways to prove that: watch the monthly credit card statements, watch your bank statements, watch your accounts, watch to see if there's significant amounts of spending. And as mentioned here, again, kind of must typically be extreme and ongoing. Each spouse is allowed to continue to spend for the usual course of business or for the necessities of life. And so oftentimes a person, I've had folks ask, well, I've got to put gas in my car to get to work every day. And I say, sure, that could be seen as the usual course of business or the necessities of life. However, if you're putting gas in your car to drive to the airport to go fly to Europe and spend a couple of weeks, the court may not agree that that is in the usual course of business or the necessities of life. How do I protect myself? Well, as I mentioned, watch those statements. Certainly the best protection is prevention. And so, talking with folks, utilizing support groups, kind of, discussing kind of these problems, with friends and family and your network of how, are you seeing kind of things that are kind of out of the norm, right? Or has it been progressively kind of moving in those directions? Kind of just thinking through those things and making sure that, that you're protecting yourself. Making sure that you have access to your accounts. Do you have the passwords? Are you able to see in real time what is being spent instead of having to wait for the monthly statement? Because oftentimes that's often too late. The money is gone, and then we're trying to argue back to the court, well, he spent this amount of money or she spent this amount of money, and I'm trying to get that back. Um, certainly looking and flagging and questioning any and all unusual expenses. Like I mentioned with the Target example of like the $500, $600 charge of wait, like that's not normal. What was purchased. And so, those kind of, just being a bit more observant about, what's happening kind of around you. Um, you would want to keep organized and clear records and keep them safe. Just document, document, document. I often like to tell folks is to, if you happen to have statements or proof of this receipt or that receipt, it's send them to me so I can have them within my kind of confidential server here at our firm, instead of you relying, if that email is deleted or the text message, I mean, I've had so many situations, especially here in Colorado because of the snow, where folks say, I had all of these text messages and they are gone now because my phone fell in the lake or the snow and now it won't work anymore. So make sure that you are having backups of that information and send those to the appropriate folks so you have another copy. And like I say here below, we can investigate. We have here in the state of Colorado, we have experts that can come on board, forensic accountants to kind of trace money here, there, and everywhere to determine whether marital waste has occurred. We have folks, example, addiction specialists that can be appointed by the court to say whether or not this person has this problem, and what are some recommendations that the court can do to make sure that the children are safe. And so we can do those things, but as you can imagine, those things can be quite expensive, and it's just anything that you can do to protect yourself, the better, and knowing that also those things can be quite difficult to kind of live through. And lastly, I always want to make sure to include support groups too. I think that, again, it takes a village, right? I think that it takes a village, and, just knowing that you're also not alone in these circumstances is also very important. So, there's plenty of support groups where, dealing with, loved ones that are going through addiction problems, or, um, um, like I mentioned, there's plenty of opportunities to rely on others and support groups to just know that you're not alone. And some folks, they come with excellent recommendations of how to, certainly deal with these very important topics that oftentimes, as I mentioned, you might not get your day in court to talk about. So it's just important to know, like I said, you're not alone. But Kathy, with that, that kind of concludes the presentation, except for our question and answer period. So, but I do want to make sure that folks know that if you have any questions, please utilize our website. We have a lot of important, like I mentioned, those resources and, information, blog articles on these topics that you can look to if you need. And feel free to call us too.
Jenny, we can go ahead and get into the first question.
Great.
How does Colorado view a spouse who has been sending their income overseas for 20 years and eventually purchasing a home without my approval?
Oh, wow. Well, I can tell you, I can't speak specifically regarding what a court might do because of that kind of subjective nature that I discussed kind of earlier in the program. I will tell you that, you know, I can imagine that that was a frustrating thing to uncover once you did. And I know that I think that it would be important, it could be important for the court to know of. There could be the argument for potential um, marital waste, as I discussed. And I think that that's an important topic to discuss with an attorney for sure. But unfortunately, it's hard for me to gauge what exactly a court might do, unfortunately.
Awesome, Jenny. The next question: is anyone anywhere aware that children in abusive marriages can be victims of the no fault view?
It's another really great question. Um, I'm uncertain as to whether folks are specifically aware, but I will tell you that I do know that Colorado attempts, I will tell you that um, that attorneys and in this kind of area of practice and judges, we all are always trying to educate one another about kind of this impact of the importance and impact of different topics with children and to children. And so I think that um, and I believe that judges are always wanting to learn more as well. And so the nice thing about that is that there could be the possibility for an expert to be appointed to have those conversations with the impacts of the where it could potentially be abusive towards children. Um, in a particular circumstance. And so I think that I will tell you that I do know that, like I said, judges and attorneys are always, opening their kind of ears to hear more and be educated, which is there's the willingness is always there as far as I'm concerned. I've always heard, I've never heard of a situation where a judge has just completely shut down of wanting to know more. We're always evolving, I feel like.
From Jenny. And the next question we have, is there any consistent effort within the legal community or court system to educate citizens about what no fault divorce really means?
So similar to the last question, I think that the the I will tell you, like I mentioned, that I believe that the court system is always wanting to learn more, right? And that includes all kind of actors of the same. We're always learning more the impacts of, this piece for children or the impact of this against a person. And, certainly as one can imagine, the the science and kind of those impacts are always evolving and we're always learning more. And so again, I stand by that. I think that the judicial branch and the legal kind of community of the state of Colorado in this kind of family law context is always willing to learn. We're always willing to learn. We're always willing to um, you know, even like I said before, change terminology to make it more applicable. And, like I said, before it was child custody. But the legislature understood that maybe we need to change that. It doesn't necessarily need to be, kind of this possessive interest over the children, but yet let's call it what it is. We're allocating who's responsible for what with regard to this kiddo. And so I will say that, like I said, I do stand by that. I think that the judicial branch and um, all of the players within the same are always willing to learn more.
Great. We do have a few questions from our audience. The next one would be, what is to prevent an ex-spouse to lie to the court about addiction or adultery in order to influence a decision?
That's a great question. I will tell you, that is, as you can imagine, that's kind of why I mentioned this document. It's so important to have the documentation there. And you may say to me, well, Jenny, it's hard to prove a negative, right? How do I prove a negative? And, but the Unfortunately, as you can imagine, in some circumstances, it becomes kind of a he said, she said type kind of circumstance. And so, you want to make sure that you are providing credible information to the court. And of course, always never lying on the stand, always providing the truth. And so anytime that you can provide additional information to help clarify for the court, well, on this date at this time this was spent, or this person saying I had committed adultery, here's where I was, and here's my spending habits on that day, and here's why this is not true. um those are it can boil down to that documentation. Now, proving, whether a person has an addiction problem, sometimes I will tell folks, well, this person is alleging that, this person has an addiction problem. Well, prove them wrong. Demonstrate to the court, well, here's my hair follicle test that shows that I am not taking any drugs. Here is, my proof of my sobriety of, you know, many UAs, or feel free to randomly test me on, doing different, like I said, tests, etc. So, appoint this expert that can assess me and to determine whether or not I have an addiction problem.
Thanks, Jenny.
Sure.
We have another one. If there is a history of a transaction for the life of the marriage, then could it be considered marital waste? In other words, the same bill month over month for years before the divorce filing.
It certainly can be. Absolutely. I don't think there's a specific period of time. I mean, it's all, I go back to that kind of subjective nature, right? Like, is it going to be relevant to the court or not? And, some of those relevant kind of questions. Well, did this person know about it? Did this person approve of it? Did this person, agree that this expense should occur, or should have known about it and they just chose not to, um, almost know about it, if that makes sense. And so I think it really, unfortunately, kind of the standard lawyer answer is it depends, and it would just depend upon the facts, the very specific nature, and how long it occurred, etc. But I will tell you, throughout a pendency of a divorce, the court can, we have certain, tools in our tool belt of being able to review statements. I mean, folks can ask back for many, many years if they believe it's relevant to the case.
Yeah, thanks, Jenny. We have a couple more questions. The next
Sure.
one, spouse does not want me talking to them on the phone or by text. Is this normal, and how am I supposed to get documents to them? For example, tax returns.
Um, That's an interesting question. I think that one is very kind of, I think we would need a bit more context. And I think it's important to make sure that you chat further with an attorney on that subject, because, I don't want to say, yeah, sure, it's no problem, go ahead, because I think it's important to make sure that you're understanding kind of the context, because if there's domestic violence, allegations, or if there's a protection order in place, you don't want, that person might not want to, you might not want to further that, those kind of pieces by attempting to communicate, and those allegations by attempting to communicate. So I think that to answer that specific, question, I think you might want to discuss further with an attorney, if that helps.
Thanks, Jenny. We'll get into the
Sure.
last one. Relative to adultery and addiction, already mentioned as an influencing factor in custody, etc. Do the courts in Colorado also view the mental health of one parent in cases where one spouse has multiple attempted suicides as a major factor when determining custody of the children?
Great question. I will tell you that, the court certainly can and most likely will, because I believe it's the second factor, maybe the third factor. I mentioned that best interest of the child factors. And one of the factors that the court it's explicitly enumerated within the statute is the mental health of the parties involved and the children. And so I believe that that is a specific factor that the court must assess when allocating parental responsibility.
Thank you, Jenny. Now we're all out of questions, and so I just want to close the webinar and thank you to everyone for attending the webinar this evening. We would like to offer everyone a free consultation. You can call our offices at 303-622-5502 to schedule the consultation using the code WISER together. And I hope everyone has a great evening, and we hope to all see you at the next WISER Together webinar.